Hello, everyone. I am Jacob Stein, and welcome to this presentation on structuring foreign investment in the United States. I am an attorney practicing in Los Angeles with Aliant. We are a global law firm focused primarily on cross-border work, and my own practice, to a very significant extent, deals with structuring international tax and business transactions. We represent a lot of foreigners who are either investing in the United States, engaging in some sort of business deals like joint ventures or M&A activity in the United States, as well as foreign individuals and families who are doing something on a more personal level, like buying real estate in the United States, or looking to immigrate to the United States, either on a temporary or a permanent basis. So over the next hour, we will talk about a lot of the issues related to how we structure foreign investment in the United States. And there are quite a few things to consider, kind of different topics. A lot of what we will be talking about deals with taxation. I would say primarily this deals with taxation because taxation becomes the major planning obstacle and the one topic we need to plan around the most carefully. Everything else should be fairly easy and straightforward and should not be that different from any other sort of an investment structure you would set up for any other client. So, for example, from a corporate standpoint or real property law standpoint or estate and trust standpoint, what we do for foreign clients is not that different than what we do for a U.S. client. Maybe some minute distinctions here and there, but not that much of a difference. But when it comes to tax and what we need to do to make taxation work in the most optimal way, and how there are differences between our U.S. clients and our foreign clients, that is all about tax. So we will spend a lot of time talking about taxation. So what are some of the issues that we need to think about when we do have a foreign investor that we are looking to represent? And again, this may be someone who is looking to invest in real estate. This may be a foreign corporate entity that is looking to acquire a U.S. subsidiary or enter into a business transaction. It can be all kinds of things, right? So any sort of inbound flow of money into the United States that will be used to acquire something in the U.S. So first of all, there are different types of investment structures for foreign investors, where we'll talk about them all in a few seconds. These structures will look at a number of factors. They will look at the income tax consequences of different types of structures for foreign investors. These structures will look at the estate and gift tax consequences of different types of structures. And then, of course, there are non-tax considerations, like, for example, liability protection that different structures will afford our clients, the degree of privacy that we will afford our clients. So let's move on to slide number 3, investment structures for foreign investment, and talk about how these different factors play in the context of some specific structures and what are some of the pros and the cons of these different structures. So note that there are, 5 and sometimes maybe 6 or 7 different alternatives as to how a foreign investment in the United States can be structured. In my experience, having represented lots of foreign investors do not want the U.S. government to poke its nose into their affairs. So to the extent they can do this legally, they would like to structure their investments in such a way so that there is as little disclosure made to the U.S. government as possible. So we will look for ways to do that. And then privacy, and I think this is sort of correlated, privacy is also a significant consideration for most of our foreign clients. And different types of foreign clients will have different privacy requirements, so different reasons for why they are seeking privacy. So for some of our foreign clients, privacy has to do with just purely cultural norms, right, where they just culturally do not want the world, they do not want others to know what it is that they have, what it is they are up to. And then we need to set up structures that accommodate those needs. Some foreign clients are concerned about their political enemies or their business competitors somehow getting wind of what they are up to. I mean, there are all sorts of reasons why people seek privacy. And it's not really that important for us to know why it is they want privacy, but it is important to figure out if this is something that a client considers to be a significant objective, and then to accommodate that objective that they may have. So how do we pursue privacy for our foreign investors? That partially depends on what it is they're investing in and what other structures we are looking to set up from either a corporate or a tax planning standpoint. But I will give you maybe a couple of simpler examples to illustrate this point. Let's say we have a foreign individual who is looking to invest in U.S. real estate. And very often when foreigners come to the United States and buy real estate, which, as we all know, happens fairly frequently because we are a safe place to park wealth for a lot of foreigners. They will go and talk to the real estate agent, the real estate broker, who will usually not only help them find property to buy, but it will also give them advice, for better or worse, on how to structure that investment. And most real estate brokers and agents are not experts in structuring transactions for privacy or liability protection or minimizing taxation. So they just sort of pass on the knowledge they've acquired along the way. And perhaps that does not often serve the client's best interest. And sometimes, real estate agents, of course, are looking to simplify their own life. And they may want clients to acquire real estate in the United States just in their personal name, because that's the simplest, right, easiest, most straightforward way to go. And of course, there is no privacy if that is the case. Or they will say to the client, why don't you set up an LLC to own the real estate? And that sounds like we're off to a good start. But then that LLC gets registered with the state's Secretary of State, and the client's name gets disclosed on the Secretary of State filing, and that becomes public information. So what should we do for privacy? There are a couple of alternatives. A frequently used structure where we're looking for really something that is very, very simple. Maybe something as innocuous as a revocable trust, right? What we commonly refer to as a living trust. This is a trust that is commonly established for estate planning, right, to avoid probate, pass assets on to the kids and the like. But here's something that can be done with a living trust. The living trust can be given any name we want it to have, right? There is no legal requirement that the trust have any sort of a formulaic name. Name it anything you want it to be. And then so long as our client is not the trustee of the trust, this becomes a good privacy shield, right? So let's say that our foreign client sets up a trust and we name it, the High Mountain Trust. Just a generic name we came up with, right? The High Mountain Trust. And the client's accountant here in the United States, Tom Smith, is the trustee of that trust. Right? So title to the assets, whether it's real estate or bank accounts or whatever else, title to the assets will be Tom Smith, trustee of the High Mountain Trust. Right? That's how title will read. And therefore, our client's name is not untitled. And that asset is not in a very obvious, very direct, very visible way, not connected to our client. Right? It's connected to Tom Smith, trustee of the High Mountain Trust. And it may not then be easy for someone to connect that asset to our client. And this is a structure that's commonly used not just for foreign clients. We use this a lot for celebrities. Sometimes we will use this for politicians, really anyone else who is looking for privacy. It's a very simple, inexpensive way to camouflage title to real property. And so just a simple living trust. As you would imagine, a simple living trust like that does not help us really with any other goal that we may have, right? There is no sort of unique tax structuring that it will enable us to engage in, because the living trust, the trust that is revocable, is ignored for all tax purposes. And then a trust like that also does not give us liability protection because it is revocable, but it does give us privacy. And if that is really the only concern that a client has, and sometimes it is the only concern that a client would have, it may be a structure worth considering because it is simple, it is inexpensive, and it does give us a nice degree of privacy. In some states, I think in the Midwestern states primarily, these types of trusts are often referred to as land trusts. So basically, it's a trust that is revocable and has a generic name. If a client wants more than just privacy, if they want liability protection, like they're worried about being sued, right? Because they've all read stories how litigious the United States is and how everyone gets sued as soon as they arrive in the United States. Well, perhaps they want a structure that gives them some substantive liability protection and not just name camouflage. And if that is the case, now we are talking about irrevocable trusts to hold title of assets, or maybe a limited liability company. So why irrevocable trusts and why limited liability company? So from a privacy standpoint, both irrevocable trusts and LLCs can have generic names. We can pick any name we want to. And again, we can bring in someone else, like a client's friend, accountant, business manager, lawyer, what have you, to be either the trustee of the irrevocable trust or perhaps the manager of the LLC, so that the client's name does not appear on any publicly filed paperwork. So with an LLC, I think it's probably more straightforward for most listeners, and most people are familiar with how LLCs work. So one note for foreign investors: if we do have an LLC that is a disregarded entity, you would historically expect that there would be no filings for an LLC that is a disregarded entity. But that is no longer true for disregarded LLCs that are owned by foreigners. There is now a disclosure requirement with the United States government. It's not a tax, it's just a disclosure form, and I apologize, I don't recall the form number. But U.S. LLCs that are disregarded entities that are owned by foreigners now have an additional disclosure form that needs to go to the Internal Revenue Service just to disclose ownership information. And this is a result of a lot of pressure by the OECD over many years on the United States. The OECD and the European community, many countries have been very unhappy, particularly with the state of Delaware. Many countries perceive, and the OECD as well, perceive Delaware as a tax haven and sort of a jurisdiction that should be blacklisted because of the degree of privacy you can have in your filings in Delaware. So some of you may know we can register a limited liability company in Delaware on a fully anonymous basis. And there are a couple of other states, I believe Wyoming and New Mexico also allow that. But Delaware has always been kind of the most notorious of all these jurisdictions. They've done a great job of marketing themselves. So that's the jurisdiction that most are aware of. So in Delaware, we can set up a limited liability company, and the identity of the manager, of course, the identity of the members is not public information. That information, the information of who is the manager is provided to the registered agent, but that is not public information. So there's no easy way for a would-be plaintiff or creditor, a government agency, or anyone else to connect that particular entity to a particular person, right? Because The only information that is publicly available is the identity of the registered agent and not the identity of the manager. And we have used these Delaware LLCs, these sort of more anonymous Delaware LLCs, for many, many years. We continue to use them certainly for U.S. clients, still work great for U.S. clients. And we do continue to use them for foreign clients as well. But there is now this disclosure to the U.S. government. Now, it's a tax disclosure, so it does not make the ownership of the LLC public information, right? It just goes to the IRS. So it is something that foreign clients need to be aware of. And LLCs, of course, do give us some substantive liability protection because now our client no longer owns that piece of real estate or that the company they acquired in the U.S. They now have a membership interest in a limited liability company, and the membership interest in a limited liability company is not subject to attachment by a creditor. The creditor can place a lien on distributions, but they cannot actually attach the membership interest. So it's some substantive protection. Similarly, with the irrevocable trust, if our client owns assets in the United States through an irrevocable trust, then the client does not own the asset of the trust himself, right? He is not deemed to be the owner of the trust assets. The assets are sort of separate and apart from our client. They're just separately owned by that irrevocable trust. And of course, that gives us a lot of protection. And the irrevocable trust, just like the living trust, can have a generic name, third-party trustee. So we're getting privacy, we're getting title camouflage, obfuscating ownership of assets. Okay, so that's privacy and liability protection. I find that for our foreign investors, these issues are much more of a concern than for most U.S. clients, privacy and liability protection. So something for you guys to keep in mind. Okay, and then the rest will be tax. So let's look at how these particular structures, direct investment, partnership, domestic corp, foreign corp, and hybrid structure play into our analysis. So looking, for example, at the direct investment, right? So foreign direct investment in the United States, again, it can be in U.S. real estate, business, bank accounts, securities, whatever it may be, intellectual property, collectibles. What are the advantages and disadvantages of our foreign client, be it a foreign individual or foreign entity, just taking ownership of U.S. clients, of U.S. assets directly in their name? Well, the first advantage would be simplicity, right? You don't need to set up any structures. You just acquire assets in your own name. You do not need to hire lawyers. You do not need to consult with anyone. You do not need to pay anyone. You just take a title of foreign assets and you're done. U.S. assets and you're done. Any other advantages? Well, there is no double tax that you would have with a corporation, with a foreign or domestic corporation structure that we will discuss in a second. Which is, it's nice not to have that double tax for income tax purposes. What are the downsides of the direct investment in the United States? Well, the downside is there is no privacy, right? Because the asset is titled in the client's name. There is no liability protection for that very same reason. And then from a tax standpoint, our foreign client has to file tax returns in their name in the United States. And remember, a lot of foreign clients do not want to have any filings with the U.S. government. But if they own income-producing assets directly, they have to be the ones who file tax returns in the United States. And then, of course, the big downside of owning assets directly in the United States is that the assets will be subject to the U.S. estate tax, right? So any assets that an individual, or this applies only to individuals, that an individual owns in the United States are subject to the U.S. estate tax on that. And as we'll discuss later, foreigners do not get the $11 million exemption that U.S. taxpayers get. So for foreigners, it's a big, big concern being subject to the U.S. estate tax, and we do need to structure around and direct ownership of assets, even though it is simple and not expensive, does not give us privacy, does not give us liability protection, does result in U.S. tax filings, and does result in the U.S. estate tax. If the foreign investor invests in the United States through a partnership type entity, so like a limited liability company or a limited partnership, we have improved a couple of things. We have improved privacy because now assets are titled in the name of an entity, and perhaps it is more difficult to connect that, to connect that to our client. And certainly liability protection, right? Again, the client now owns an interest in an LLC or a limited partnership, and those interests are not subject to an attachment order by a creditor. From a tax standpoint, we really haven't improved much because the client still owns U.S. assets in the form of interest in these entities, so there is still an estate tax, the U.S. estate tax on that. With LLCs and partnerships, there are these look-through rules to who are the partners. And for example, if the LLC or the limited partnership is deemed to be engaging in the U.S. traded business, under this look-through rule, the foreign investors in this LLC or partnership will also be deemed to be engaging in the U.S. traded business, which means they now have tax return filing obligations with the U.S. government that they may not like. Moving on, domestic corporation, domestic in this context meaning a U.S. corporation that is owned by a foreign shareholder, and now this U.S. corporation is buying real estate or operating a U.S. business or doing what have you. Advantages, disadvantages, so of course there's a bit more liability protection with a corporation than with direct investment, but not as much liability protection as with an LLC or a limited partnership. There may be some privacy, but not as much privacy as, let's say, with the Delaware LLC, where the name of the manager is not publicly disclosed. With a corporation, you do have to disclose the identity of corporate officers and perhaps directors in most jurisdictions. So it will be harder for our client to distance himself or herself from this corporation. So there's less privacy, less liability protection. There's still an estate tax, right? Because our foreign client still owns a U.S. asset, and any U.S. asset, with a couple of exceptions, would be subject to the U.S. estate tax. Now, the advantage of the domestic corporation is that our foreign client no longer has a tax filing obligation in the United States, because now this domestic corporation will be filing a U.S. tax return, and there is no look-through from a corporation to the shareholder. So like in an LLC or a partnership, we look through, and the activities of the LLC or a partnership are attributed to the owners. With a corporation, there is no look-through, right? And the corporation sort of stands on its own 2 feet, and its activities are not attributed to the shareholders. It's a more of a passive investment, right? So if you have a U.S. corporation that is engaged in the U.S. traded business, and this corporation has foreign shareholders, they will not be deemed engaged in the U.S. traded business because they just have a passive interest in the corporation, shares of stock, and there's no attribution. Now, with the foreign corporation, we are starting to change things a little bit. So we still have the same privacy and liability protection pretty much, although maybe privacy is a little bit better. Maybe liability protection is a little bit better than with a U.S. corporation, right? Because now for U.S. plaintiffs and creditors, perhaps it is a bit more difficult to discover who is behind this foreign corporation or to file a lawsuit and collect against the foreign corporation. So partially it will depend on whether this foreign corporation has to register in the United States, as a foreign entity that is doing business in the United States. And then partially it will depend which foreign country the corporation is organized in. In some countries, there are public registries of ownership of corporations, names of directors, officers, all of that is publicly available. And in some countries, it is not publicly available. So now we need to be mindful of where we are setting up this foreign corporation. There are also, as you will find if you practice in this area, there are cultural preferences where we will set up this foreign corporation to structure inbound investment in the United States. For example, Chinese, Hongkonese, Taiwanese clients love to use BVI corporations to structure pretty much any offshore investment, including funneling investment into the United States. I don't know if anyone knows why they like BVI. BVI was originally kind of famous and popular for use of offshore investment funds. And perhaps that's where it originated for a lot of Asian investors. But they still continue to loyally and doggedly use the BVI to set up entities. There's really no advantage to the BVI versus many other countries that are out there, just as good as dozens of other jurisdictions. But if you're Asian, you likely will go to BVI or perhaps Samoa or Fiji. And then Europeans may be using one of the tax havens in Europe, Malta or Cyprus. They may be using those islands in the English Channel, like Guernsey and Jersey, or they may be using other jurisdictions in the West Indies. South Americans will definitely use the Caribbean jurisdictions, and Eastern Europeans like Russians, Ukrainians usually will use Cyprus as their jurisdiction for the foreign corporation through which they will funnel investment into the United States. And also kind of this comes up a bit later in the tax discussion, but just to throw it out right now, one of the considerations of where to position this foreign corporation will have to do with income tax treaties. Right? We'll see later how the United States imposes all sorts of withholding taxes on foreign investors. But there are tax treaties that will either mitigate these withholding taxes or perhaps even sometimes eliminate them entirely. All of a sudden, it becomes, from an income tax standpoint, it becomes important to figure out where we position this foreign corporation for which we will funnel investment into the United States. So, for example, a lot of Russians and Ukrainians, when they invest into the United States or some other countries, will run the investment through Cyprus because, for example, Russia has an income tax treaty with Cyprus, and then Cyprus has an income tax treaty with the United States. So it allows these Russians to funnel money into U.S. investments and take advantage of back-to-back income tax treaties. And it may not be that easy with other countries, right? Or at least other countries that will not impose their own significant tax on these foreign investors. So with a foreign corporation, the big advantage is that we avoid the U.S. estate tax, right? Because with a foreign corporation, the foreign individual client, they own shares of stock in a foreign corporation that is not a U.S. asset, that is not subject to the U.S. estate tax. So that's a big benefit. Likewise, with the privacy, as I said, there's more privacy, there's more liability protection. Filing requirements. With a foreign corporation, the foreign investor has no filing requirements in the United States because they are not the ones investing in the United States. The foreign corporation is. Right? And if this foreign corporation was set up for the specific purpose of investing in the United States, it will file a U.S. tax return, and then the only information made available to the United States government will be the activities of that foreign corporation in the United States and not the activities of that foreign corporation elsewhere in the world. The downside of the foreign corporation that does not exist anywhere else, or at least a foreign corporation that is directly investing in the United States, is the so-called branch profits tax, which is a second layer of tax that a foreign corporation that invests into the U.S. directly without a corporate subsidiary will be subject to, and we will discuss the branch profits tax in a little bit. And then finally, there are hybrid structures. Like, for example, we can have a foreign corporation that owns a U.S. corporation that in turn invests in U.S. assets. We can have a foreign corporation that invests in a U.S. disregarded LLC or invests in a limited partnership. So in each of these have advantages and disadvantages. Likely, I would say that for most foreign investors, the structures that we see most frequently will either just have them go through a U.S. limited liability company that's a disregarded entity, and then perhaps set up an offshore trust, which will own an interest in that U.S. disregarded entity to, first of all, escape the U.S. estate tax, and second, to make sure that the foreign individual is not subject to tax return filing obligation in the U.S., or some sort of a hybrid corporate structure like a foreign corporation holding an interest in a U.S. corporation, which allows us to control the timing of the tax on the dividend that is paid from the U.S. to the foreign corporation. Okay, moving on to slide number 4, let's start talking about income taxation of inbound investments. And when we're dealing with income taxation, the very first thing we need to discuss is who will be deemed an alien, a non-resident alien for U.S. tax purposes versus a U.S. taxpayer. And this is the most crucial distinction. The most crucial distinction. Because if someone is deemed to be a U.S. taxpayer for income tax purposes, then they're subject to, the exactly same rules that everyone else is subject to, that you and I are subject to. But if we have a foreign investor who is deemed for U.S. income tax purposes a non-resident alien, a completely separate tax rules. Right, so this non-resident alien versus U.S. tax resident, it's an income tax moniker, right? It's a term of art, and we arrive at this classification based on certain tests. Like, for example, someone who has U.S. citizenship is always a U.S. tax resident. Even if this person lives abroad and maybe has never even been in the United States, right? It could be someone who was born outside of the United States to U.S. Citizen parents, and therefore acquired U.S. citizenship that way. And that person has never stepped foot in the United States. They lived their entire life outside the U.S., but because they do have U.S. citizenship, because the United States taxes citizens on global income, what's called worldwide income, regardless of where they live, regardless of residence, you have a U.S. taxpayer who is taxed on worldwide income, even though they've never sort of received any economic or other advantages from the United States. And this is something we run across often. I was just yesterday speaking to a client who spent the past 15 years living in, I believe, in Italy, and he does now have some assets in the United States, and he is now concerned that he has 15 years of never filing income tax returns in the United States, and eventually, he is worried that the IRS may catch on to him. And now that he has assets in the United States, there will be something for the IRS to pursue. So for foreign client, this classification from non-resident alien to U.S. tax resident is big. Not only do the tax rules change, the tax base changes in a very significant way. So you will find that someone who is a non-resident alien, someone who's truly a foreigner, right? It's a foreign investor who has foreign citizenship and who lives pretty much in a foreign country. Maybe they will occasionally come to the United States either to travel or work or check out their investments, conduct due diligence, but these are, shorter, more periodic visits, and they're not deemed to be a U.S. person for tax purposes. And they're treated like a foreigner. And foreigners, these so-called non-resident aliens, are only taxed by the United States on their U.S. income, U.S. sourced income. And they are not taxed by the United States on their foreign sourced income, right? Because the United States would have no jurisdiction to tax a non-resident alien on their non-U.S. income. And further, non-resident aliens are not subject to certain disclosure requirements that the rest of us are subject to, like the requirement to disclose overseas bank accounts or ownership interests in foreign entities. And that does not apply to non-resident aliens. So other than citizenship, how do we know whether a foreign investor is a non-resident alien, or perhaps they've done something, conducted themselves in such a way so that they are classified as a U.S. tax resident? Well, it turns out that a foreigner can be classified as a U.S. tax resident based on not just citizenship, but also based on whether they hold a green card. A green card holder, as soon as they have their green card, and I believe they're physically present in the United States, they are a U.S. taxpayer as of that day. And then under the what's called the substantial presence test or the physical presence test in the United States, someone who is present in the United States for X number of days a year, and it's a test that has sort of this rolling average, the special weighted formula that we use to see how many days was this foreigner present in the United States this year, last year, and 2 years ago. And we weigh those days and add them up. And the formula is in your outline materials if you're interested. And once we exceed the 183-day threshold, we have now somebody who is deemed to be a U.S. tax resident. So notice that these rules do not look at intention. It doesn't matter whether someone intended to be a U.S. tax resident, right? Once you acquire citizenship, you are a U.S. tax resident. Once you acquire a green card and you are actually physically in the United States, you are a U.S. tax resident. And then, of course, simply spending a lot of time in the United States, you may acquire U.S. tax residence. And the biggest downside, other than just all the filing requirements and disclosures of everything you have going on, is the fact that now that you are a U.S. tax resident, you are taxed on your worldwide income by the United States government. And for a lot of foreigners, that is just like, wow, I'm taxed on my worldwide income, and I do not even consider myself a resident of this wonderful, amazing country that we all live in. How can that be? And, you know, a lot of foreigners will come from countries where their income tax system is really not as organized, not as robust as the one we have in the United States, or the tax rules is simply just a lot more attractive. For example, we represent a lot of very wealthy French families, and these very wealthy French families often have residence in Morocco, right? So they all will have, nice homes in Morocco, and they will spend some amount of time there. And they will not be spending a lot of time in France. So even though they are French citizens, because they are not living in France all that much, France does not tax them, right? Because France taxes based on resident. And then in Morocco, they are not citizens, and they also do not have any income sourced to Morocco, right? All of their income, all of their assets outside of Morocco. So they wind up in a situation where they are not paying any taxes in France. They are not paying any taxes in Morocco. They're not paying any taxes anywhere else, most likely, right? And now they come to the United States, and the United States says, hey, you've been spending kind of a lot of time living here. You know, we would like a pound of flesh. We're not going to tax you on your worldwide income on assets that have never anything had to do with the United States, right? And that's, obviously a significant tax hit to a lot of these foreign clients that we have. And these rules apply, the presence test rules apply obviously only to individuals. Foreign entities are not subject to this rule because there is no such thing as physical presence for a legal entity. But for foreign individuals that we know, if they're spending, some decent amount of time in the United States, we will have them keep a calendar, when they arrived in the United States, when they left the United States, and, maybe a couple of times a year, they will email us their calendar so we can calculate where are they, how close are they to 183 days. And you may not be surprised to learn that very often our clients will send us this calendar, and we are scrambling because, the very next day they have to leave the United States or they exceed the 183-day threshold. And once you've exceeded it, you exceeded it. You are a U.S. taxpayer, U.S. tax resident for that year, and you're taxed on your worldwide income. So if you do not exceed the number of days test, so you're a non-resident alien or you're a foreign corporation, then you're only taxed on your U.S. sourced income. And this can be U.S. sourced passive income like investment income. It can be income from a U.S. traded business. There are special types of income, or special tax systems with respect to real estate. So the rest of the time, let's move on to slide number 5, and let's talk about the different categories of income, different tax rules that apply to foreigners, and how the United States taxes foreigners with respect to their U.S. sourced income. So the biggest category, or the most important one, the one we see in practice most often, is the so-called FDAP income. FDAP stands for Fixed Determinable Annual or Periodic Income. And this is primarily passive income: interest, rents, royalties, dividends, things of that nature. And then this also includes salaries, commissions, bonuses, and certain other things. These categories are not defined by statute. We get these more from case law, revenue rulings, and the like. But mostly it is passive income. And foreigners, so again, NRAs or foreign corporations that have passive income in the United States are subject to a withholding tax. And this withholding tax applies at the rate of 30%. Right. So as a quick example, just to put it together for you guys, let's say our, German client bought some shares of Microsoft, bought them directly here in the United States, and Microsoft declared and paid him $100 dividend. Well, under the FDAP withholding rules, Microsoft, which will be what's called the withholding agent, must withhold and remit to the United States Treasury 30% of that dividend. So they're only allowed to actually give their foreign shareholders $70 from the $100 dividend, and the $30 goes to the United States Treasury. And if Microsoft screws it up, and if Microsoft remits the entire $100 to its German shareholder, then it's Microsoft who is liable to the United States Treasury for the tax that was not withheld. So this is a withholding tax. Notice that it's fairly simple and straightforward, right? There are no deductions to calculate or credits. Figure out what is the passive income, apply 30% to the gross amount of that income, and that's your tax. And you withhold it at the time of payment, give it to the United States government, and our foreign investor is done. There are no filing requirements in the United States. There are no tax returns to do because we know what the tax is. It has been paid. No further action is needed or wanted. 30% withholding tax on passive income is fairly high, right? It's fairly prohibitive. So this is one of the major advantages of an income tax treaty. Right? The primary purpose of an income tax treaty is to avoid double taxation of the same income by two separate countries. So that's why treaties will have provisions who gets to tax what type of income, depending on the circumstances. The treaties will have a tie break provision, meaning that if someone can be taxed somehow by both countries, we will go through this escalating set of factors that will help us determine which country gets to tax. So only one is taxing. But the second the secondary role of the tax treaty is to reduce the withholding tax on passive income. And income tax treaties in the United States has, I would like to say, around 60 income tax treaties with various countries. These treaties would reduce the withholding tax on passive income to anywhere between 0 to 15%. 15% is the most common. That's sort of like standard, right? And then depending on how strong of a trading partner the income tax treaty is with, the withholding can be even less, right? And the withholding can go maybe all the way down to 0 for certain countries and for certain categories of income. So we'll have different withholding taxes for interest income, for dividends or rents, royalties, and the like. Okay. So by the way, if you do represent U.S. clients who may have foreign investors, you do have to get certificates of non-foreign status. Those are forms W8. From these folks or your clients need to know whether they do withhold, and if they withhold, how much. Is the withholding reduced by an income tax treaty or somehow eliminated, or do they withhold the full freight? Because they will be liable if they fail to withhold when they should. If we have a foreign client who is operating a business in the United States, then that client is deemed to be engaging in a U.S. traded business, and engaging in a U.S. traded business is not only taxable, but it does something a bit different. If you have a foreigner who is engaging in a U.S. traded business, they will now be taxed on their U.S. income, and not just income on that U.S. traded business, but even connected income. It's called effectively connected income under what's called the force of attraction rule. A lot of terminology, right? They will be taxed on that income, and really, let's assume all income in the United States, is if they are a U.S. taxpayer. So they are non-resident alien, but if they're operating a traded business in the United States, and they're either operating that traded business in the U.S. directly or through some sort of an agent, usually a dependent agent, then they're deemed to be operating a U.S. traded business, and they are now subject to exactly the same income tax rules that anyone else who operates a U.S. traded business. So they file an income tax return, they calculate their income, they get their deductions and credits and so forth. Then we have capital gains. Capital gains is kind of unique. There's always been, or for a long term, has been a policy of U.S. Congress to encourage foreign capital investment in the United States. So foreigners are not taxed on U.S. capital gains unless it's a capital gain from the sale of real estate. A gain from the sale of real estate is treated as income from a U.S. traded business, and foreigners are taxed on that, and we'll talk about that in a sec. But all other capital gains, like a capital gain on the sale of stock or capital equipment or intellectual property, what have you, just no capital gain. Foreigners are exempt from capital gains, taxation of capital gains by the United States. So that's very attractive by foreigners. And similarly, foreigners are also not subject to taxation on income from U.S. banks. So this is interest income earned from savings and loan institutions, so like regular banks, not investment management firms, and that's just not subject to tax. We do want to, again, encourage foreigners to deposit money with the U.S. banks. And then finally, what's called portfolio interest income. This is a category of income that leads to a lot of kind of creative planning and allows us to avoid U.S. taxation for many foreign investors. And portfolio interest loan provision provides that if you have a foreigner who lends money to somebody in the United States, they may be able to avoid the withholding tax on interest that they get paid on that loan. Right? So if you borrow money, if you're a U.S. person, and you borrow money from a foreigner, then you will pay them interest income, and ordinarily that interest income is subject to the 30% withholding tax on FDAP. But if we can qualify this loan as what's called a portfolio interest loan, it's not that difficult to do. The foreigner is simply not taxed on interest income they generate on that loan. FIRPTA, Foreign Investment and Real Property Tax Act, was enacted in 1980 in response to what was seen as Japanese takeover of U.S. real estate. And FIRPTA provides that the sale of U.S. real estate is no longer treated as other capital gains, and there is now a capital gain tax that is imposed on sale of U.S. real estate by foreigners. There is also a withholding that is required. So when a foreigner sells U.S. real estate, the buyer must withhold 15% of the gross sale price remitted to the United States Treasury. The foreigner can then next year file an income tax return, calculate their capital gain tax on the sale of U.S. real estate, apply the 15% that was withheld as credit, and either get the difference refunded back to them or pay more, as the case may be. FIRPTA is very well thought through rules. It's very difficult to avoid it by putting real estate interests and entities and the like. And it's only a timing issue, so to speak, right? So we know we will pay capital gain tax, and we know that 15% will be withheld today. Really where FIRPTA trips people up, I think, is when they believe there should be no tax. Like, for example, we have a foreign client right now who is selling U.S. real estate at a slight loss. That's possible in this market, but he's selling at a slight loss. There still has to be a 15% FIRPTA withholding, unless we can get an exemption withholding certificate from the Internal Revenue Service. And in this case, I do not know if we can get it quickly enough before the sale closes. So this client will have to collect only 85% of the sale price. And then next April, he's going to file an income tax return and get the amount withheld refunded back to him. So it kind of sucks, but it is what it is. And finally, the branch profits tax. The branch profits tax provides that if you have a foreign corporation that is operating a U.S. traded business directly, it is subject to a second level of tax. The second level of tax is intended to replace a tax on dividends that would have applied had a foreign corporation operated its U.S. traded business through a U.S. subsidiary corporation. So imagine you have a U.S. subsidiary corporation, makes money, it gets taxed, and then it declares and pays a dividend to a foreign parent. And it gets taxed again on that dividend under the 30% FDAP withholding rules. Again, maybe reduced by an income tax treaty. So you will sometimes have foreign corporations looking to avoid that second layer of tax by just operating in the United States directly. So branch profits tax was enacted to basically replicate a double tax structure for these foreign corporations. And there's some very interesting planning that can be done with the branch profits tax. All right, we have a little bit of time left. Let's move on directly to the slide called U.S. transfer tax, slide number 10. And you will note that the residency with respect to the transfer tax is not based on the number of days present in the United States. Sometimes it's not even based on whether the foreigner has a green card. This is based purely on intention. Is there an intention to create a U.S. domicile? And there are different ways to test that intention. Like you look at the life the foreigner has created in the United States. Do they have a family here? Have they bought a house here? Have they said out loud or written somewhere that they intend to live in the United States permanently? And there are cases, I recall, where you have foreigners living in the United States, obviously on a visa, for like 20 years. And they're deemed to be non-resident aliens for estate tax purposes because they always had the intention of returning back to their home country at some point in time. So we look at intention. And here, because intention is somewhat subjective, and we may be able to argue both ways. Sometimes we can argue there is an intention to have a U.S. domicile, and sometimes not. We need to be aware of what is better for us. And this varies from case to case. In some cases, we may want to have a U.S. domicile, U.S. residency for estate tax purposes. In some cases, we don't. It's really a question primarily of what is the overall estate that our foreign client has and where are the assets, like how much of the assets are in the United States and how much are outside the United States. $60,000 assets in the U.S. estate tax. So you have a foreigner who is, who has, let's say, a lot of assets overseas, millions and millions of dollars, and just a little bit in the U.S. Someone like that we want treated as a non-resident alien, a non-resident for estate tax purposes. And then maybe a foreigner who has a few assets outside the United States, but a ton of assets in the U.S. That person we want to be a U.S. resident because we want to get the $11 million exemption for them. So we do have someone who is, truly a non-resident. Then they get the $60,000 exemption, and then any other assets they have on top of that in the United States would be subject to the 40% estate tax. That's why it's so crucial for our foreign clients not to acquire U.S. real estate directly in their name. It will just, the value of that real estate, almost half of the first dollar, will be subject to the 40% estate tax. So this applies to all sorts of U.S. assets, including interest in U.S. entities. And where it does not apply would be foreign assets. So that's why often we do want to use foreign corporations or even foreign trusts for our foreign clients to own U.S. assets. And then it does not apply to bank accounts and portfolio interest loans. Those are not subject to the U.S. estate tax. So how do we plan to avoid the transfer tax, the estate tax for foreign clients? So first, again, we plan to own U.S. assets through foreign entities or foreign trusts, because then the client is direct. And then there are a few treaties that estate treaties. These are completely separate income tax treaties, and there are only 30 or so estate tax treaties that at least will prevent double taxation. But where the planning primarily gets done is with by using lifetime gifts. So foreigners are subject to the U.S. gift tax on gifts of U.S. assets. So again, it can be U.S. real estate or an interest in, let's say, U.S. corporation. But if the foreigner is subject to the gift tax, there's no exemption at all. There's no $60,000 exemption. Foreigners are subject to the U.S. gift tax off of the first dollar gifted, same 40% tax. Here's what's interesting. Foreigners are not subject to the U.S. gift tax on gifts of intangible assets, because intangible assets technically are deemed to be foreign assets if they're owned by a foreigner. So intangibles can be intellectual property, right? They're those intangible assets. An intangible can also be an interest like in a limited liability company or a limited partnership. There's no share certificate. It's an intangible, deemed to be an intangible interest. And because it is deemed to be an intangible interest, a foreigner can get an interest, a gift an interest in an LLC to someone else, and the U.S. gift tax does not apply. So often when we do encounter a foreign client who has already acquired U.S. real estate in their own name, we will have them transfer that real estate into a U.S. limited liability company and then gift that LLC into an irrevocable trust or to their kids and out of the U.S. gift and estate tax system. And then finally, to close this out, the next to last slide, pre-immigration tax planning, just kind of, I mean, this in and of itself can be an hour-long presentation, but just quickly to note for now that foreigners who have somewhat significant assets should very carefully consider pre-immigration tax planning. Once they become U.S. taxpayers, they're subject to tax on worldwide income, which means if they sell an asset that they own and they cannot prove what the basis is or base, so when that value has been paid, they may have income passive source that has never had anything to do with the United States, but because now they're a U.S. taxpayer, they are taxed on their worldwide income. So very often before a client like that moves to the United States, we want to engage in a few types of planning. One is we want to make sure that we increase income tax basis of assets to fair market value, which often can be done quite simply. So then following immigration, these clients can sell their assets, at least assets outside the United States, and not be subject to the capital gain tax. If they have existing foreign entities, we want to strip out accumulated earnings and profits to avoid ordinary tax on distributions in the future from these entities. We may want to move certain assets, at least assets outside of the United States, into offshore irrevocable trusts. This is done both for income tax planning and for estate tax planning, and sometimes for asset protection. We may want to accelerate income recognition. So if there is a large income recognition event that will take place before they become U.S. taxpayers, defer loss recognition. We may want to move assets to kids or other family members. So there's a lot of planning that can be done for wealthy foreigners. So, unfortunately, in an hour, there's only so much that we can cover. So this was intended kind of as a highlights of structuring foreign investment in U.S. real estate. There are a lot of nuances to it. Your program materials provide you with a lot more details and a lot more guidance. And I always make myself available to anyone who's listened to my presentations. At any point in time, whenever you listen to this presentation, if you do have questions, please feel free to reach out to me. I'm Jacob Stein. I'm a partner at Aliant in Los Angeles. My email address is jstein@alliantlaw.com, and Aliant is one L. And I welcome your questions, and I thank you for listening and hope to see you guys another time.